Hey everyone, I'm Diana Davison, an advocate for the falsely accused and wrongfully convicted, and I'm here with veteran criminal lawyer Joseph Neuberger. So we're here today to start. We actually want to do a series, but today we're going to start with the reason Joseph and I met, which was changing rules of evidence in what was called Bill C-51. If you want to explain to people what that was.
Yeah, so after a certain case, which has been well known, the Gomeshi case, there was a lot of public outcry from certain advocacy groups about the rules of evidence that was applicable in sexual assault cases, and in particular, evidence that was in the possession of the defense, like text messages or pictures or emails, and whether it was fair to a complainant in a sexual assault case to just spring that on them, or whether this was evidence that should be disclosed prior, and whether it's relevant in the first place, because it may not be relevant as it could go to the twin myths. And so through a lot of pressure, our federal government responded with fairly draconian legislation, Bill C-51, which put into place a number of measures, but most importantly for what we're talking about, it changed the old 276 application, which was what was commonly referred to as the rape shield provision. And now it broadened the ambit of what evidence will have to be vetted by a judge. So any evidence that can constitute a record in the possession of the defense lawyer's possession, or the accused, will have to be vetted on an application. So that could be email communications, pictures, videos, audio recordings, text messages, anything even related to the subject matter of the charge will have to be now disclosed to the Crown and to the complainant. The complainant has a right to have a lawyer, and there has to be a hearing under Section 276 and 278 to disclose this evidence and determine whether it's relevant. Does it go to the twin myths? If not, and it is relevant, then the complainant still can argue about whether it should be admissible. And, interestingly enough, in order to admit this evidence, most of the time you have to have an affidavit of your client testifying as to what the history of the relationship was, how they came into possession of this evidence, what its relevance is, etc. And now that person will testify, so the accused will testify, and typically you'd have the Crown in the past cross-examined, but not very much. But now, because the complainant has standing in the hearing, this is really important for everybody to understand.
Yeah.
The complainant now has standing and has their own lawyer, and their own lawyer can cross-examine the accused. And so this changes the whole dynamic, where it used to be just between the defense and the Crown. Now it's tri-party litigation, which can be much more cumbersome and will have much more impact on individuals as far as affordability of trials. And it's a prolonged process because you have a two-stage process now. So you pick one date and then you have another one a couple of months later. It's a tremendous change to the way we used to conduct business. And the disclosure of defense evidence that the complainant ought to be aware of or know of, frankly, is, in my opinion, and remains something which is unknown in our justice system other than alibi evidence. And so I find this to be very draconian and very damaging to the right to a fair trial.
Well, you used the word catastrophic when it was first being discussed. But of course, like, this has passed, and there's a lot of stuff to unpack in there, because there's like 276 and 278. 276 wasn't, as you said, in place already, and so but 278 was third-party records searches, which is a different thing. And so complainants did have standing in third-party records to protect privacy rights.
Right.
But now the change now is it's not just sexual evidence that they're concerned with in advance. Now it's any evidence, whether it's sexual or not. And as you said, the subject matter of the charge means the actual event that's in dispute, the actual incident that's being alleged.
Right.
So, but those have come to pass now, December 13th, I think, of 2018.
Correct.
And I would say that what we're seeing and the way this is playing out is catastrophic.
Yes.
That it's essentially breaking the justice system for a few different reasons that we can get into. But those are currently before the courts right now. And that's part of the chaos that you can see is I've seen applications going in saying, I don't even think these qualify as records. Right? Is this a record for the purpose? So all of these hearings that are being held are obviously at the expense of the accused.
100%. There's no cost to the complainant. It's absolutely at the expense of an accused, and it's very expensive.
Mm-hmm. So it's an access to justice problem.
100%, because now you have to prepare a very detailed notice, a factum, an affidavit, and attend court on 2 separate days to argue this, which really, in some cases, doubles the trial time for a person who has to seek their own justice.
And if things continue the way they're going right now, it could end up causing big interruptions mid-trial process. So it would be difficult, I would think, to actually be able to predict how many days the trial is going to take when you're trying to book court time and stuff.
Yeah, it's an excellent point, because there's some lawyers and there's some thought that, for example, text communications or email communications aren't records. Because in the past, when we spoke about records in the criminal justice system, those were records that belonged to the complainant, like therapy records or certain medical records, which we understand why they would have a privacy right. The accused would have to subpoena those records to court and then argue relevance, and the complainant absolutely would have a right at that hearing, but that's about their own private records that the accused doesn't have or should not have access to. Completely different situation now.
And you want to make sure people can speak to therapists and doctors openly without concern about...
Absolutely. They have to be able to have that. And in my practice, where I've done tons of sexual assault defense work, rarely have I ever gone after records like that. But now they want to characterize records, including communications. And there are some lawyers who are saying it doesn't include communications, but I think the broader conception now, and judges are still quite confused, is that anything is going to constitute a record.
That's what I'm seeing, is a lot of confusion where they're like going, I don't even know, how I'm supposed to decide this, because the defense lawyers don't actually want to produce the evidence in advance unless they have to, and so they're asking for a decision on whether or not their evidence has to be produced, and they're going, well, until I see it, I don't know, and then...
and just think about it from practical terms.
Yeah.
So now in the past, where you would have two people who were either dating and then something allegedly happens, and there's communications before and after about that particular night, and let's say those communications are very helpful to the defense. One could honestly be puzzled as to why we should vet those communications, surely because the complainant would be aware of what they had said in a communication, but now you have to disclose that. And not only disclose it to the complainant, she will have the benefit of counsel who can cross-examine the affiant, the accused, and then have plenty of time to tailor their evidence to accommodate whatever is in those communications that would have been useful at trial. So it may completely negate the value of that evidence. Well, it's very, very disturbing.
And that became relevant to a recent decision where they're saying, when you look at it, like, all witnesses are excluded from court until they finish testifying, or until they testify, because they don't want to have their evidence infected by what they've heard other people say in court.
Correct.
And so that's the principle that some judges have said create the problem for allowing these advance hearings to take place, which what they've ultimately said at this point is the only way for this to be okay is to have them testify first. But I think that brings up another important point, is that you don't know what evidence you're going to use until you've heard the testimony.
Well, that's an excellent point. So we can explain this. So in the criminal process, we would have, as the defense, a copy of the statement of the complainant. And so we get it, normally I transcribe it, so we have it in written format and video, and you can read it. But as you note aptly in some things you've said and written before, it's one thing to read it and have it in a statement. It's another to have live evidence of that witness. Not until they testify do you really have a complete understanding of all of their evidence and how it unfolds. And it's at that point that you really make crucial decisions about how you're going to cross-examine and what evidence is relevant to cross-examination. So that's an excellent point. And as you said, there are a few decisions out there now where those courts are saying that there is no need for an application until the complainant has testified, so the accused is now fully aware of the evidence they have to face.
Well, when you make these applications, you have to tie it to something specific, right? So when you say that you want to bring something in, you have to explain, what was said that makes it relevant to the case. And, sometimes things can actually become quite relevant, which on the surface you wouldn't think they are, but it will go to sequences of events that lead up to. Right. And of course, say people can act in all different kinds of ways prior to an event. They can always take consent back again if they've given it in advance.
Absolutely.
They might act in unexpected ways afterwards, but the importance isn't what they did, it's whether or not it matches what they said.
Absolutely. I mean, there's no dispute, and anybody who views this shouldn't think that what we're trying to do is take away from the rights of a complainant or somebody who is truly a victim. And all the evidence has to be viewed in entirety when a court assesses it. The difficulty we have now is it's not so much about how the person behaves afterward as being in line of a certain behavior you would expect. It's now giving evidence that's highly relevant to actually what was going on between those two people, and the complainant having advance notice of really where the defense is going on it, and having the opportunity to be prepared. And I'm not, again, suggesting that every complainant who comes to court is automatically lying. That's not at all what I'm saying. But we need a fair balance. Right. And there needs to be an even playing field, because the truth is the truth. If somebody's testifying about what happened, as difficult as it is to testify in a trial, they usually can testify and give their evidence in a relatively straightforward manner and withstand cross-examination. But now what we're doing is, in the cases where we can have a miscarriage of justice, which does happen, we're handing over relevant evidence and allowing the complainant to be able to work through that with their own lawyer. And this is really unprecedented. It's incredibly damaging, and it's something that people have to wrap their head around. We didn't need it, and it's broken the system more, in my opinion, and it's put at risk individuals, both male and female if they're accused, depending upon your relationships, of being convicted wrongly of something that they did not do.
Well, I think there's a lot of things about sexual assault cases that are unique. One of them is that you can be convicted based on nothing other than the testimony of the complainant.
Right.
Right? So there's no corroboration required. And you and I have talked about this. A lot of people will say, how can this person get convicted? There was no evidence.
Right.
Which, of course, testimony is evidence.
That's right. So I will often from people who come into my office and say, well, there's no evidence. And then I have to explain to them, and it's a difficult situation because they think somehow I'm advocating on behalf of the complainant or the Crown. The evidence of somebody, their statement, and then ultimately their evidence in court is evidence. And our law has suggested a long time ago that there needs to be no corroboration of a complainant's evidence in a sexual assault case or other proceedings, because sometimes this violence takes place in a very closed setting where there are no witnesses and no way to corroborate it. So if a complainant testifies and there's no evidence, let's say physical evidence or anything else to corroborate it, that doesn't matter. That evidence can be sufficient to find somebody guilty beyond a reasonable doubt. And people have to wrap their heads around that. That's very real. And that means that there has to be careful preparation in order to cross-examine, because you have the accused evidence versus the complainant's evidence.
Right.
And that's
and then it comes down to the quality of that evidence.
Correct.
Which, what I'm seeing a lot of advocates push for is what I feel is junk science about how memory works.
Yes.
And so they're re-educating police, prosecutors, judges to view complainants' evidence differently, in which a lot of things that would be considered unreliable, right? So gaps in their memories, inconsistencies, these are all now being alleged to be evidence of assault.
Right.
And one of the things that they've done is they've told police not to ask too many questions, not to expect a linear storytelling. But the results, I think, is that they're not being questioned thoroughly at all. So as the defense lawyer, like, your statements aren't going to be as comprehensive. Right?
Yeah.
And now they've taken away preliminary hearings.
Yeah, so you've raised a few very interesting issues. So first of all, statements are not as robust as they used to be, and sometimes you could find that there's a 2-hour, 2.5-hour interview, and now you may find that there's a 45-minute interview. And there will be a great absence of very particulars that are relevant to the actual allegations just missing. And so that's a problem. And then add to that something that you mentioned, which is there's no preliminary inquiry. So in certain sexual assault cases where the allegations are so serious, the Crown can elect to proceed by indictment. And that's a more serious case where the Crown can seek a penalty in excess of 2 years less a day. So somebody could get penitentiary time. Normally, in the past, for the last, few hundred years, you could have the right to a preliminary inquiry, where you would have a hearing and the complainant would testify, and if the statement was not as fulsome as it should be, you will hear the evidence, and then you can cross-examine, and there's no determination of guilt or innocence, but you get to understand the evidence in its totality. Right. Now, the government, because they're on this track of trying to modernize the criminal justice system, or in other words, I think, stack it against accused, what they did was, for any offense punishable of 14 years or under, there's no preliminary inquiries. That includes, very significantly, straightforward sexual assault cases. So in a case where the Crown would normally ask for 3 to 4 years in jail, there's no preliminary inquiry. If you couple that with like a 45-minute interview that does not have a lot of detail, an accused may have very little evidence to go on, and really that's now left to the defense to try and do their own investigation, maybe interview witnesses, maybe try and interview the complainant, who knows what they can do, to try and create more evidence and determine where the areas are that you need to delve into as a defense lawyer. And it's a combination now which is very, very dangerous.
Well, you can see in the discussion in Parliament while they were making that decision about the preliminary hearings that it was one of their main intentions was to prevent complainants in sexual assault cases from having to testify more than once.
Correct.
Right? But at the same time, it can prevent them from having to testify at a proper trial if it's discovered in a preliminary that the evidence isn't going to be sufficient, right? So it can actually spare them.
100%.
It can spare them embarrassment, and I don't know, you're still in a preliminary, you're still in a courtroom, so there's still that sort of people who aren't used to, like lawyers going to courtroom for work, right? But most people going into one, it's quite intimidating, right? Montreal, not so much, because they don't have the pomp, like the big dais and stuff like that, but it can be really intimidating. I think there are certain things that can be done to get people familiar with that environment before they testify.
Yes.
That would, help put them at ease. There's a lot of legitimate problems with testifying in what's obviously going to be a very intimate type of testimony that you have to give, discussing, sexual activity and how clothes come off and things like this. But we can address, there's a lot of different ways that those could be addressed. But what they've chosen to do is change the process in a way that has essentially broken the legal system.
Yeah, no, this is another catastrophic elimination of due process, in my opinion. And so you're right. So when you look at the discussions in Parliament for this legislation, they were talking about modernizing the criminal justice system, but really the underpinnings of that were comments, which you read and I read, about saving the complainant, or as they use the victim, from testifying more than once. And that's a real problem, because as difficult as it is to testify, we have to have a fair system. And the accused has a right to know the case that they have to meet. And preliminary inquiries were incredibly important. I just have a case now where we had a preliminary inquiry. The case is being withdrawn because the reasonable prospect of conviction was extremely low, and it was extremely beneficial. And I think fair-minded and reasonable Crown attorneys will say it's a shame that this has been eliminated now, because this was a very effective tool for them also understanding their case, because Crown attorneys, by and large, who I've met, want to ensure that they are doing the right thing. And if they see that there's a case which is not sufficient to go to trial, normally they will act judiciously and do the right thing. Preliminary inquiries were incredibly helpful. And it's also better than testifying in front of a jury. So if it's going to be by indictment and you could elect to have a trial in front of a jury, that's very challenging, because the complainant has to testify in front of 12 strangers in a jury panel. Well, preliminary inquiry is still in courtroom, but it's less traumatic. And if you get to the nub of the case, then it can have all sorts of benefits towards a resolution without a trial. It's all gone now.
Yeah. Well,
and
you
bad.
mentioned a case to be answered, and that's one of the things that I saw that came up in one of the recent verdicts, saying that these hearings will have to take place after testimony, and that is that until the prosecutors have presented their case against the accused, constitutionally you have a right to say nothing, because you won't have to speak until there's a case to be answered.
Correct.
Right? But I find a lot of these legal phrases, it would really help people to understand how they work a little bit better, because all of this essentially seems to have started from public outrage.
It did.
Where the public's being told that the system was broken, that it didn't work in sexual assault cases. And so these were supposed to fix it, but ultimately now it actually is broken. And that happens when people are fixing something that ain't broke. The system's never going to be perfect. Right?
No, this can't be a perfect system. This won't be a perfect system. We have, however, a very good system of criminal justice in Canada, probably one of the beacons in this world. And now it's been tampered with by what I believe was a very interventionist government who had a knee-jerk reaction to maybe 2 or 3 cases. And they decided to change legislation very significantly, where both the defense bar, the Crown, and judges are confused and are not happy with these decisions. by the government. And it's extremely challenging now for an individual to have a fair trial. And it doesn't just impact on sexual assault cases, because cases that are in domestic violence as well, where it could be quite severe, also no preliminary inquiries. And so this has a broader reach, and it's for all offenses under 14 years. So this has a very broad reach and has a very significant impact on due process, and it's very troubling. And and just to give an example so everybody understands, these are knee-jerk reactions by the government. This was not well thought out. It's not like this was in the works for years prior to, some bureaucrats within the justice system was working on new legislation, whatever government was there. This was in direct result to the Jian Ghomeshi case.
Yeah.
It is in direct result also to other cases and advocacy groups that are advocating on behalf of victims of crime. And then within Bill C-75, just so we can cap this off, another major amendment was in jury trials, an accused and Crown would have 12, there are other circumstances, but would have 12 preemptory challenges. Mm. So when picking a jury, they could excuse a juror based upon their own knowledge and skill as to who might be appropriate to sit on a jury panel without ever articulating a reason, a preemptory challenge. And that had been in place for a very, very long time. And because of the case in Saskatchewan, which was the very unfortunate death of an Aboriginal young man,
Colton Boushie,
right, with the Saskatchewan farmer, the defense on that case properly used their peremptory challenges, but excluded people, and there was nobody on the panel of an Indigenous background. And so when the conviction came down, the Justice Minister at that time was outraged and was really inappropriately scathing of the jury. And what we saw now as a result of that was an immediate reaction to eliminate preemptory challenges so that the defense can't do that. And somehow that was to promote more diversity on a panel, which is absolutely inaccurate, because now if you have no preemptory challenges and no way to ask questions of a juror, you can just wind up with 12 white people, 12 non-white people. You have no idea what you're going to get, because it's just the first 12 or 13 who show up. Yeah. And that's it. And this has been in place in order to protect individuals of certain backgrounds against bias. So you'll have no way of rooting it out. And now no participation of an accused in picking their own jury. And so it's unconstitutional in my opinion. But this is an example of knee-jerk reactions from a federal government because of one case.
Yeah.
And all of this is, in my opinion, there are others who may disagree, all this is knee-jerk reactionary legislation, which is highly inappropriate and damaging to due process.
Well, an interesting thing about the complainants in the Ghomeshi case, not just the ones that went to court, but a bunch of other ones, that it was actually fairly common to hear people say, well, I don't necessarily want him to go to jail. And I wonder about that in terms of encouraging people to go to police. A lot of these complainants are saying they don't think jail would be the right solution, but of course a criminal charge is a path to jail. Right? And so I've kind of wondered if people actually understand the severity of incarcerating somebody.
Right. And it goes beyond that. So first of all, anybody who is really a victim of an offense should have the absolute right and be supported to come forward and report it. That being said, once a charge is laid, if it's a serious offense, not only will it lead to jail, but it leads to a conviction. And a conviction, if it's a sexual assault case, will lead to being labeled a sex offender, having to register as a sex offender, not being able to find employment. Good luck to try and find a job where there's not some type of security check. Mm-hmm. And then it can lead to incarceration. And incarceration's not easy. I mean, Canada, they may think that our jails are this, nice wonderland. It's not. It's very difficult in our jails. It's very challenging to survive in there. And we have to be careful that only those who deserve jail because they've been properly convicted on evidence that proves the case beyond a reasonable doubt should go when it's warranted. But now we run the risk of our system of justice being used for other reasons. Right. And that bothers me. And certain complainants who did come forward in that case, and we're not passing judgment on the truth or veracity of that evidence or if other people came forward, but if you go to a police officer and you make a complaint, it's going to result in a charge. It's going to result in an arrest, and it can result in somebody being convicted of a very serious offense with a long lifetime type of stigmatization, and that's it. You can't get around it.
Well, another big event that was very media driven was this Unfounded series that was Robin Doolittle's work, and she did some really intense work,
Yeah.
going through. Unfortunately, my feeling is that she was going through numbers, not actual cases.
Right.
And so what they did was they looked at all the unfounded rates in all the different police departments.
Right.
And now there's a lot of pressure, not just to lay more charges, but they were also going through old cases that were closed to reopen them.
Mm-hmm.
And it kind of struck me that this reasonable doubt, like prospect of conviction, right?
Yeah.
When cases have been closed already, it kind of it does bring up whether there's a prospect of conviction if the case wasn't really that strong. But now the impetus is to create good-looking numbers,
Right.
and I think, and I do hear from police officers that they don't feel very good about having to lay charges in a number of cases. But ultimately, they think, well, let's let the courts work it out. Right? It's not my problem. Let the courts work it out.
Yeah, well, look, they have a difficult situation because police, with the policies that are in place now, are robbed of their own discretion. And police, in many, and I'm not just talking about these types of cases, but they have generally a good feeling, a good hunch about certain issues in cases and when they're investigating them. And they're essentially robbed of their discretion in domestic and sexual related cases because there's a mandatory charge policy. In fact, I've seen cases where the officers have said, look, to the accused, I know you want to say something, but it's not going to make a difference. We're going to charge you anyway, so maybe you just want to get a lawyer and then you can decide what you want to do after that. Because they have no discretion. That doesn't mean that investigations have evolved over time to be more sophisticated at investigating sexual assault cases or other cases. And we've seen that growth over a period of several decades where you have specialized units and officers who are used to examining and asking questions of witnesses who are involved in these offenses. But many officers do express that they no longer have, and haven't had for a long time, the discretion to do their job. And they don't want to just see themselves as simply a stenographer taking down a statement and then laying a charge. They want to do more in investigation. And I've seen cases where police have gone out and done extensive investigations, but many others they haven't. And that depends on what evidence is available. But they are absolutely robbed of their discretion. And then in prosecution, there are Crown attorneys who will pull cases. But now, given the era we live in with the new legislation, one can forgive a Crown attorney for not wanting to make that decision because of the pressure to prosecute and because of the policies that are put in place. And so, again, we see discretion at another level being hampered because of these zero tolerance type of policies.
Yeah.
Doesn't help anybody.
Interestingly, in terms of modernizing the justice system, and one of the things they were trying to do was to deal with issues that the Supreme Court had said were unconstitutional, right? One of the big ones they were supposed to address were mandatory minimums.
Well, or the Liberal government, when they came in as part of their original platform, was to address mandatory minimums and look at the criminal code when it was put in place by the Conservative government and deal with them, and they didn't. And we've seen now that the Supreme Court and courts of appeal have eliminated mandatory minimums for almost everything. There's a few that are still in existence now, and maybe justifiably so. But in all the sexual assault, like sexual interference and other charges, save and except for luring now, mandatory minimums have been struck down. Mm-hmm. And so our government didn't deal with it at all. So you can imagine also if a new government were to come in soon and reinstitute mandatory minimums, and then we have this combination of no preliminary inquiries, Bill C-51, changes with legislation, where certain evidence can be excluded even though it's relevant. My God.
I know.
People
it's just
can
like bricks on the cart.
Absolutely. I mean, can you imagine that someone being convicted when there's very slim evidence, but because of all this, they get convicted, and then they're looking at a mandatory minimum of a year or 2 years in jail. I mean, that is absolutely devastating to an individual.
Well, for how far we've gone already, it seems to me, and I've publicly said that I think the government should just admit they don't care about wrongful convictions anymore, because. But in crafting these things, like you said, they didn't. And one of the things we're seeing play out is that they've passed something, but then they didn't actually decide how it was going to be implemented, right? So the preliminary hearings being gotten rid of.
Well, and peremptory challenges was a brilliant one because we started a murder case right after that when a decision came down from a Superior Court judge that, no, you don't, it's constitutional. And then in that case, nobody knew what to do. Like normally you'd have this archaic process where the potential juror stands up and looks at an accused, and the accused looks at them, and then you would gauge what's going on. It's gone. So nobody knew what the process would be.
Right.
So you just pick the first 12 or 13 and that's it. And now we see that legislation being challenged. It'll go to the Court of Appeal. But the government didn't think about this, because let's just imagine this for a moment. Let's say the legislation under Bill C-75 that got rid of preemptory challenges is declared unconstitutional because an accused has a constitutional right to participate in selecting their own jury. Think about all the cases that have gone on in the last few months, murder cases and other serious cases, where they did not have preemptory challenges.
Right.
You order them all back to trial?
I know.
It's completely unthought about. Like they
Well,
did not apply their minds to it, in my opinion.
That's what I'm seeing with all these split decisions on rules of evidence and the sexual assault trials coming up, is that my big concern was, okay, well, this guy was just told he has to produce all of his texts and everything prior to trial, prior to her testimony. Somebody else is told, no, your constitutional rights would be violated, therefore we're going to do something different. So we've now got different people going to trial with different rules of evidence.
Right. So in many cases I have right now, we have a number of these applications filed. We're going through the process, and let's just say somebody gets convicted and then we appeal, but the Court of Appeal at some point determines that this legislation is partially or completely unconstitutional in relation to this process. Imagine all those other cases. Order them all back for trial. I mean, I can imagine the pressure on an appellate court to go, what do we do here? Because just practically speaking, many, and I'm not saying they will think this way, but many could think, oh my God, listen, like there's hundreds, if not thousands of cases that may get ordered back for trial.
Yeah.
Over something that really, I think, was completely unnecessary.
Well, there were a lot of submissions in, the hearings they had before they passed C-51 on the new rules of evidence. There were a lot of submissions from defense lawyers that explained exactly how it was going to break the system and what was wrong with it. And none of that seems to have been incorporated at all.
It completely fell on deaf ears.
And then, of course, they're able to pass legislation that can leave a big vacuum of understanding anymore, like what everyone's supposed to do. There's got to be, it seemed to me there should be like a test ground or something like that before they actually pass it. And it was like, where you're not actually testing and experimenting on human beings,
Yeah, I mean, sadly, the definition of records could have been made much more clearer. You could set out the process much more clearer. They didn't. And it is what it is, because this was, I think, legislation that was drafted and put forward in place in a rather quick manner, without careful thought. I mean, those who drafted it will absolutely argue against me and say, no, it's carefully thought out, it's constitutional, and it's doing the right thing. I think it's the complete opposite. And time will tell now over the next couple of years how this plays out.
Well, okay, if we go with a couple of the recent decisions then, that the only way for this to be constitutional is to have the testimony of the complainant, and then you have to make your application at that point,
right,
saying what you want to discuss. There's like the original way that hearings would be held for 276 hearings, say, or 278, which are even more complicated. But then there's voir dires that are like more common for mid-trial exploratory kind of thing.
When a legal issue arises.
What's the difference between a voir dire and, like, say, a full application that you would make for a 278?
Well, on an application, you can have a voir dire, which is a hearing within a hearing. So for example, on a 276 application, it would be done on a voir dire. So evidence would be called. It's not evidence at the trial, but it's within this hearing, and then a determination is based upon the argument and the evidence heard. Mid-trial, you can have legal issues arise with respect to potential evidence from a witness that one side or the other may object. The judge can't answer the question whether it's admissible, relevant, or admissible in a vacuum, and so you may call the evidence on a voir dire to test it and see if it is admissible and relevant. Similar when you're dealing with expert evidence. If the Crown wants to call a particular expert, or the defense does, you may voir dire it prior to a trial to determine whether it's appropriately expert evidence. Mm-hmm. But this is a bit different, because although this is done on a voir dire, you are taking real evidence that you would normally cross-examine the complainant with and just handing it over ahead of time.
Right.
And so that type of process just really, in my opinion, robs an accused of what is so important in cross-examination, is asking that first question where the witness is not necessarily anticipating it, because then you're going to get a truthful answer. Right. That's what happens.
I know.
And when somebody gets to think very carefully about it and how to craft their answer, that's a problem.
Well, how do you think in terms of the timing? Because like making an application, you have to actually, file the correct forms and you have to lay everything out that
Right.
you want and you have to explain why it's relevant. All that has to be in the document. So you don't
Absolutely.
just walk in and make an oral argument about it.
No.
So, so if you have to wait until they've testified, then essentially what you're going to do is like, say they finish testimony midday, then you'd be like, all right, so tomorrow we'll come back and have hearings.
Not going to happen. At that point, if that's going to be the process, then you'll have to adjourn for a period of time, and the lawyers will have to go away and draft their material. So you need a notice of factum and possibly an affidavit and file with the court, and then a lawyer has to be appointed for the complainant. So this is going to take time. Imagine you're doing a jury trial. So let's say it's a case where the Crown's elected by indictment. You're in front of a jury. The issues arise at that point. What do? How do you deal with it? Well, maybe a judge might say, okay, we've got a jury trial here. We're going to adjourn for a couple of days, and we're just going to do the best we can to get this sorted out. But that's not what this was intended to be like. That's not the way the legislation was supposed to unfold.
No.
And you can imagine it could cause mistrials. It will prolong trials. We have the decision from the Supreme Court of Canada some time ago called Jordan, where trials are supposed to take place within an 18-month period in the Ontario court and then another 18 months in Superior Court. So you can see that a case may go way beyond the 18 months if we have to stop mid-trial, file materials, get a complainant and a lawyer, argue it all out. Who knows? Cases could be stayed for delay.
The limits can be extended if the delay is caused by the defense.
Yeah, you're right, but I would argue that is absolutely not the defense issue.
Right.
This is an issue arising from the legislation, where if those two decisions right now and others come that say that you are not required to disclose your evidence until the complainant is testified, then you can't blame it on the defense.
So I'm just thinking like in terms of logistics then. So if they have to testify first, I'm thinking that you would have to go into a trial and say, well, to the prosecutor, how long do you think it's going to take for you to get all of your evidence in chief? And then only book the court for the days expected for the in-chief testimony.
Yeah, it's totally impractical because our courts are struggling with insufficient resources. As much as this government talks about both provincial and federal about tough on crime and all that other stuff, they're loath to put in resources into the system, and courts are chronically understaffed, and we still need more judges, and so court time's precious. Mm-hmm. And so to try and book half a day just to get in the evidence and then figure it out later on, good luck. Because the other thing is, it's very hard. You have to get transcripts. You have to then come back on another day, and the witness will have to testify, and you have to be able to get the same momentum in the evidence. It's very damaging to the trial process. I think all of this could have been avoided by just taking a different tact. If we needed to put in place more resources and support for complainants when testifying, that could have been done without damaging the due process element and fair trial element of our criminal justice system.
Well, that is one of the things I think about too, is like I don't just like to look at what's broken, I try to figure out how to fix things. And because it was public advocacy and media misinforming people, I think, quite often on, and not necessarily intentionally. I think it's difficult because of the language of the law and stuff.
Yeah.
When people go to court, sometimes it's difficult for them to understand what was said.
Right.
I've been in court with people before as a support person, and we left and they went, oh my God, that was terrible. I went, no, that was great. Things went really well. Or it'll be the reverse. They think something went really well, and I was like, no, that wasn't very good, actually.
Yeah, I mean, it's hard for people to perceive it, but...
So, I think the same thing can happen with media who are covering courts more and more, but don't necessarily understand what it was that happened. And so you get this impression from headlines that are aimed at creating, more clickbait kind of stuff.
Yeah.
And
you can easily create a moral panic when there is no need for one.
So, that's kind of one of the things I look at too, is like what kind of stuff can I put out into the public, which is what I'm hoping to do actually with interviewing you, is to help people understand the system, how it works, why it works that way, what the principles are behind it, and hopefully restore some faith in the justice system. So part of that...
My faith is a bit tarnished in the system, but...
Yeah, so most lawyers though. You get jaded?
No, it's not jaded. I've truly been an advocate about our justice system in Canada, because I believe we do, by and large, have a very good judiciary, have good, hardworking, honest Crown attorneys, all who've been trying to row in the right direction. The difficulty is when you've got government meddling in this and creating moral panics when they don't exist and creating knee-jerk reaction. That's when it causes damage. And that's where it disturbs me, because it becomes so much harder for clients to access justice. And whether it's a complainant or an accused, we shouldn't make the system one particular way for one class of complainant, because there are other cases which are extremely serious where witnesses testify under difficult circumstances like homicides or home invasions and other things where it's equally as traumatizing for them. Mm-hmm. But they seem to get left out of the mix. It's just this one category. And so why I feel a little bit more disheartened by what happened, and my concern for the justice system now, is that a government that was very interventionist has decided to say these category of crimes deserve special treatment such that we're going to erode due process. They may not agree with me about eroding due process, but I think many of my colleagues and people who fairly understand the justice system will agree this is egregious, and it was absolutely unnecessary.
Well, it seems bizarre in any kind of case that the courts would want to eliminate available evidence, right? Yeah. Normally you would just say, like, sometimes it's hard to get evidence, in various types of crimes, but whatever you can gather, even if it's circumstantial or something, like, you want to get as much evidence as you can, because, like, I've seen a judge in court say, look, because the prosecutor withdrew the charge afterwards, like, she recommended acquittal, so he was like, well, we had a little bit of time on our hands then, would you mind if I just say a few words, right? Yeah. It was wonderful. But he said, look, I don't know this gentleman, I don't know the other person, I'm sitting here not knowing anything about these two people, and I have to decide, who I believe, which of course is something they're not permitted to do, right? But he was essentially saying a lot of these cases coming because there's nothing but testimony from, the witnesses, and it's the he said, she said case. There's not much more you can do than really just end up choosing between people. And I actually wanted to get the transcript from that.
Yeah, and look,
speech, because it was really interesting.
I often say to juries in some of these cases, you've seen but a small snippet of these people's lives. You've seen and heard very little about who these people are, and yet you're in a position of making a very serious judgment on the liberty interests of an individual. And we have to keep that in mind, because judges have a difficult job, juries have difficult jobs. They don't know these people, and sometimes the result can be quite obvious. Sometimes it's not. Mm-hmm. But that's why we have proof beyond a reasonable doubt, the presumption of innocence, and we've had procedural protections which have been eroded. Because we don't know. We're not mind readers. Right. We weren't there. There's no video going on at the time that the offense occurred in many of these types of cases. And that's why these procedural safeguards are in place, because the system has to be based on cogent evidence, proof beyond a reasonable doubt, before anybody should be convicted of an offense.
Right. Well, and if we're eroding our protections against wrongful convictions, I think something has to be put in place so we can fast track reviews of convictions.
Well, there are appeals.
Yeah.
But then, sometimes the grounds for appeal is quite narrow, and judges don't want to be second-guessing other judges in the trial courts who've had the opportunity to watch the witnesses testify and assess their evidence. But, I will see what appellate courts will do. I mean, I think judges are evolving in the sense of looking at this evidence and making their judgments not in a biased manner and trying to be fair. But I think this is damaging, and we're going to see it play out. And we have to be very careful too, because the elimination of preliminary inquiries in other types of cases, like domestic-related cases, where it can come out of a really bad high-conflict divorce where there's custody issues and all sorts of other messy things, people have agendas. They have agendas as to why they want to go to court and make allegations. And I think we've got to be really careful. Yeah. And we'll see how time plays out.
Anything involving a hostile divorce situation should definitely be carefully looked at.
You've got to scrutinize it very, very carefully and be concerned. And I hear over and over, even though there is evidence to establish that the complainant may in fact not be telling the truth, even if you have a recording in certain cases, and we have one of those right now, the Crown's still going to prosecute. And I think we see sometimes, in my opinion, a gender bias against men, where I haven't seen that before. I mean, I've seen issues, but now I'm seeing it more.
I've seen a couple of decisions where they felt that there was a stereotype about the way men behave at play.
And I'm seeing more of that now, and I'm seeing that, in certain jurisdictions you can pick and choose that if laying a charge may depend on the gender of the particular accused, and I'm seeing that a little bit more now in light of what has unfolded, and that's unfortunate. And we'll have to see how that plays out.
Now, you actually like jury trials.
I do.
Right? But that.
Well, I did.
Yeah. Well, that's the question is, now with the whole hashtag Believe Women thing going on, I've seen a lot of, I think there was the trial of the 3 Toronto police officers that I think was a year ago. It might have been a little bit more now.
A little bit more than a year, yeah.
Where they actually had to discuss that, whether that was a question they were going to put to potential jury members, and how they would phrase it in terms of discovering if anybody had accepted or adopted that sort of, principle that's obviously not what the judge is going to be telling them about, how to weigh evidence and so on, right?
That's an excellent point. Yeah, and I think juries by and large want to do the right job, but now that we don't have preemptory challenges, in 2 cases where I have trials that are going to go before a jury in sexual assault cases, I'm going to be bringing an application for a challenge for cause to ask certain questions of a jury member if there's a potential bias, and I'm going to have to come up with a fair amount of psychological and sociological evidence to support that. Lord knows if I'll be successful on it, but I think we absolutely have to do that, because if there's a general belief of a particular juror or potential juror, that's important for us to uncover before they're selected to be the juror on a trial involving a sexual assault case, for example.
Well, I think this focus on numbers is really damaging as well, because people have a feeling we just need to convict more people so that the numbers look better, or so we can be proud of our statistics.
Yeah.
And the reality is every single case is like we said, these are human beings who are very complicated, and motive for false accusations is another big. Why would somebody lie? Well, of course, that's a forbidden question in court, right?
Well, yeah, but people think it.
I know.
Juries will think it, and sometimes judges will think it quietly. They won't say it out loud, but yeah.
But from studies that I've seen, actually, I was thinking it was the top third, but as it turns out, it's the number 2 reason why women have lied about rape when they asked them later, and they acknowledged that they had lied. The second top reason was they didn't know. So if they don't know, it's so the motive is just it also seems to say people are really bad at understanding their own motives.
Yeah, and I've seen cases where there have been male complainants, not in sexual assault cases, but in domestic context, where and females too. I don't want to propagate my own gender bias, but I've seen it in both, where they want to use the justice system for leverage in family court, and that can be uncovered, but it's really difficult, and that's why you have to think about these things very carefully. It's amazing how sometimes allegations come out right after there's a separation or a divorce, and then there's a battle about the house and about kids and everything else, and so. Humans are humans, they will behave the way they do, and we have to be very careful when people's liberty's at stake, period.
Yeah. I mean, the divorce the divorce problem is huge, and like you were saying, is so as soon as somebody ends up getting granted access, all of a sudden some new allegation comes up. But yeah, they are really complicated, and I think that's, there's a lot of stereotypes at play about, well, actually, this is leading into, what might be the last thing we can maybe discuss.
Sure.
And it's a huge topic for people that have watched my videos as well, in terms of why people lie and how motives play out and things like that. A lot of people want to see consequences for false accusers, right?
Right.
But of course, if you're saying somebody's falsely accused you, the burden of proof shifts.
Correct.
And they have you have to actually prove it.
Yeah.
And also, I think, there's a lot of cases where somebody may not be truthful, but they don't realize it. Like they actually believe what they're saying is true.
Yeah, that's true. That happens.
It's growing now because you have a bunch of advocates and outsiders who will tell somebody what happened to them was an assault, and then memory is malleable. So over time, their recall of what actually happened. So they're not necessarily lying when they go in there.
No, and in those
reliable.
cases, you're not nor should consequences occur for that individual. But there are cases where I had one case recently where. Clearly a witness in a case, a sexual assault case, played around with a recording where she made it with her and the accused and only disclosed to the police a 1-minute portion. And in fact, it was a 9-minute discussion. And the portion that was disclosed, she tried in a very strong fashion to try and convince the police officer during that interview that what was contained within that 1 minute showed that he was admitting guilt. And when I waited to cross-examine on that, I was able to get out that, in fact, it was a 9-minute recording. We got access to the recording, and guess what? There was a whole bunch of denials and much more context to it. And so in that case, it was absolutely apparent that the complainant witness, this wasn't the complainant, it was the complainant's witness who wanted to force this on. It was my client's former wife, had manipulated the recording, manipulated the evidence that the police had, and did the same during testimony in court. Mm-hmm. And that absolutely is an obstruct justice.
Yeah.
And again, in many instances, we don't see anything happening afterward. Now, in that case, my client just wanted an end to the conflict, and so didn't want anything bad to happen there. He was happy with his acquittal. But you can imagine in other cases where somebody has been laboring under the charges for 2 or 3 years, and there's been dire consequences, maybe in family court or somewhere else, you might go, if you're faced with evidence which is pretty clear fabrication, what happens to the other side? And sometimes nothing happens.
Yeah. I mean, it is definitely a problem. I think that improving investigations could, before charges are laid, could be a better solution than adopting some sort of an automatic charge policy.
Yeah, I mean, there are specialty units, but again, they are also chronically underfunded. Budgets for police is going down, and I think there are time constraints, and there may be other pressures put upon them where they're told not to do certain things and do other things, and that hampers their investigations.
Yeah.
And I'm dealing with a case now where they deemed certain evidence was not so relevant, so they only did a synopsis of that, where I have to now hire a private investigator and go out and interview. I would have much preferred if the police would have actually interviewed these people on video, under oath, but now I have to go out and try and track down these people. So that's a perfect example of where a more fulsome investigation would be helpful to everybody.
Yeah. Now, I have seen, in the UK, they seem to take the complainant's phone, and they'll take the phone away from the accused person, and then they take it into police custody and analyze all the data and stuff, and then decide what they're going to turn over. And there's been a big discussion about whether or not that's proper, because complainants feel like they're having their privacy violated if they have to turn over their phones and so on. But it is a difficult thing where over there, of course, the accused people have had their phones in the police possession, so they can't even search it themselves to try and find their own evidence.
Right.
Which is, I don't know how that works. But again, it does seem like if somebody's saying, oh, we'll be texted with each other, it does seem a natural thing to say, well, can you provide me with those text messages?
Yeah.
And somebody not wanting to turn over text messages from a specific moment, it, to me, seems really suspicious.
Yeah, and there are certain cases where we've been privy to what the interviews were in the investigations, and officers are asking these questions but not getting these answers.
Yeah.
And so they're trying to get to it. One would imagine it would be natural. I do see officers asking these questions, but then not getting the evidence, or not seizing it, or not photographing certain things, or not having consent of the person to turn over the phone for a data extraction, and that's unfortunate.
Yeah. Well, I mean, the trauma for an accused person, if they're innocent, is, starts from the moment they're charged.
100%.
And the system does take a long time to get through. Smaller towns, they seem to go a little bit faster.
Yeah.
Because, of course, their courts aren't as booked. But it can be really frustrating, too, where they just feel like, and I'm sure you get it all the time, where they just feel like, oh, my lawyer's not getting back to me or calling me. But, of course, you're working on a bunch of different cases.
Yeah.
And, there's nothing to do when you're waiting for a court date that's months away, right? So,
yeah. If you've got a trial set 9 months from now, it's a bit like training for a marathon. You don't want to train 1 year in advance. You got to start training as you get closer, so it's more relevant and more in the mind of the person that you're defending. But it's very difficult, because when people are charged with an offense, it can have immediate devastating impact. I mean, people lose their jobs when they're charged.
Yeah.
Just gone. And so they can be excluded from their home. If they
right
don't
at the
have
time
a job,
when they need more money, because they have legal bills.
And if they're fired, you can imagine somebody will now have to find other resources, and they're not going to get a job that will pay as well as the one they had. I mean, there's all sorts of implications which are very serious and very dire for people once they're charged.
Yeah. Well, I think the important thing is to do everything we can to ensure people are getting fair trials, and that is definitely an obstacle right now.
Right, and it needs to be fair for everybody who's a participant in the process, both the complainant, witnesses, and an accused. It has to be fair. These amendments did not help. It just broke the system more, in my opinion. and made it more easy for people to be wrongfully convicted. And we didn't need this type of knee-jerk reaction by the government, but it happened. And now we got to pick up the pieces and see where we go from there.
And yeah, I guess we'll see if it ends up going all the way to Supreme Court.
Some of this will, I think.
To get a decision. But yeah, in the meantime, all these people are just languishing, waiting for a trial and not knowing what rules of evidence to use. So,
good discussion.
It's definitely something that not just has to be fixed, but it's something that we need to learn from. So
yeah, I mean, I think we have to have a discourse
things.
of this.
Yeah.
There has to be a more sophisticated discussion about this at a higher level, so the public understands this, and that they have a more meaningful understanding of the criminal justice process and really what is an issue for our public and what isn't. I mean, we live in very safe cities. You know, people do suffer, people are victims of crime, but by and large, we have a good system of justice. We have ways of dealing with it, and sometimes these types of measures are unwarranted, and people shouldn't worry that our system was broken. Now it is, in my opinion, in certain ways.
Yeah. Yeah. Well,
that's a sad note to maybe end on.
I know. All right. Well, it was a great chat.
Thank you. Thanks for bringing this attention to these issues.
Yeah, I mean, everything is like, there's so many things within each issue too that I'm just like going, well, evidence, rules of evidence is some of the most complicated law, how you have to lay foundations for stuff.
Yeah.
And it's like, we could do a whole other video just talking about that sometime.
That maybe will be
But this is a good place to start because this is where we met talking about Bill C-51. And of course, now here we are with it in action. So
True.
All right. Thanks.
Thank you.
And we'll get back to everybody with another episode.